The starting point with precedent, I think, is quite a simple one. I'm sure it's no secret to say, well, you know, what underlies this idea is that like cases should be decided in the same way. Now, that's a very bald statement, isn't it? Like cases should be decided in the same way. We could elaborate it. The idea is if they are sufficiently alike in law and fact, and the decision comes from a court that's senior in the hierarchy of courts, then that becomes a binding decision for other courts when a similar case, similar in law and fact, comes to be decided. That's the basic idea, isn't it? My fear is that we can lose the golden thread in this subject, or to shift the metaphor, we fail to see the wood for the trees. Unless we really remember what's going on with precedent, right? Okay, yes, it's a doctrine, there is some case law on it, and we need to understand what's going on in this case law. But I think we also need to understand fundamentally what precedent is. I'm going to say this, like the argument in the politics of the common law. Precedent is really a culture of argument. That's what it is. And all these attempts by textbook writers to say, here are the rules of precedent, here's how precedent, the advantage, disadvantage of precedent, I don't think that really gets us to the truth of what's going on. And that is judges interpreting, judges arguing. That's what I mean when I say that precedent is a culture of argument. I mean, any argument must justify itself by reference to a principle. I mean, a legal argument in particular must justify itself by reference to a principle or to a rule. So a great deal of what is going on in precedent is just this, a culture of argument that makes reference to principles and rules in an attempt to resolve disputes. Textbook writers tend to step back from it, abstract from it, and attempt to describe it in a general way, and that's in a sense what we're trying to do. I think the reality of it is the only way to truly understand what's going on is to read the cases. Yes, to read as many cases as you possibly can. That is the reality of this thing. I think once we start abstracting, we tend to, there's a risk that we actually distort the practice of precedent, what judges are actually doing. And so what I want to try and do, so a slight contradiction here because I'm necessarily abstracting and generalising, I want to try and get a little bit closer to the practice of judicial precedent, the way in which judges argue about precedent, and the kind of tensions, for that is what they are, within these practices of argument. So these concerns, if you like, about do judges make law? That's one of the classic concerns, isn't it? This idea about the extent to which, say, the Court of Appeal is bound to follow its own previous decisions. In other words, Lord Denning's campaign in the Court of Appeal. The issue of the extent to which the House of Lords is, or the Supreme Court now, the House of Lords is the Supreme Court. I'm going to use that language interchangeably because obviously a lot of the main cases here refer to the House of Lords. It is now, of course, the Supreme Court. I'm going to use those terms interchangeably, just for that's just for clarity. These classical concerns, then, the extent to which the House of Lords is bound by its own previous decisions, the extent to which the Court of Appeal is bound by its own previous decisions. These, I think, ultimately reflect on that reality, that culture of judicial argument, where not only does decisions have to be justified by reference to previous cases, by the rules, the principles that previous cases stand as authority for, we have, of course, that underlying concern with the hierarchy of courts itself, which is fundamental to the doctrine of precedent. It is about authority, then. This culture of argument is concerned with authoritative arguments. And part of that idea of the authority of an argument within the practice of precedent relates to the court that decided it. And of course takes us to these issues of the relationship of the House of Lords to its own previous rulings, the Court of Appeal to its own previous rulings. Now, the other problem here is a lot of people read precedent as if it's still 1974, as if Lord Denning is still alive. Right? Now, that's a long time ago, isn't it? The Davis and Johnson, these key cases, I'm not saying they're unimportant, but a great deal has changed. One of the things that's changed is clearly the Human Rights Act. And I think a very valid question to ask in relation to this culture of argument, this practice of precedent, is the question of the impact of human rights upon it. The relationship, in other words, of the British courts to the Strasbourg Court, the European Court of Human Rights. I'm not talking about, and I'm going to stress this because I've just given a load of people zero, because they're confusing European Union law and the law of the European Court of Human Rights, European Human Rights Law. They're different bodies of law, aren't they? What the Human Rights Act does is incorporate the Convention. It makes the European Convention on Human Rights part of domestic law. There's no reference there to the European Union or the European Community. It's a different body of law. So let's not confuse the two. My argument today has absolutely nothing to do with the European Union or the European Community. It's now called the European Union. My concern is with the impact of human rights on the culture of argument, on the idea of precedent and the way in which judges understand precedent. So I think then there's three, if you like, foci for our discussion. Four, possibly, or the fourth is perhaps implicit in those other three. That is, first of all, the idea of the House of Lords. Is the House of Lords always bound by its own previous decisions? The idea of the Court of Appeal. Is the Court of Appeal always bound by its own previous decisions? And thirdly, the issue of the impact of human rights. Fourthly, I think a pervasive concern, which is this idea of judicial lawmaking. Yes, this, again, if you look at the questions in the exam, the issue is often approached through the idea of do judges make law, or some more technical understanding, some technical concern with the rule of precedent that comes out of the case law. So I'm going to perhaps say a little bit about this idea of do judges make law, our fourth concern, if you like, but perhaps deal with it more of in a pervasive sense. You know, it threads throughout other concerns. I think that there are other concerns in relation to this area. And the easy answer is, of course, judges make law. Don't let anybody tell you otherwise. How can they not make law? Judges themselves say we make law. So the issue can't really be understood in this sense that there's no argument. Of course judges make law. I think one fails to understand what's going on unless one approaches it from that perspective. The issue is, I think, given that judges make law, what are the correct parameters of judicial lawmaking? Now that takes us back to a constitutional fundamental, and a lot of common law reasoning, a lot of the considerations that we have in this course also link up with considerations in public law. So it is worth thinking across the two subjects. We know that Parliament's sovereign, we know that Parliament has supreme lawmaking power. Therefore the lawmaking power of a judge must be subordinate, must be secondary to that of Parliament, which it always was. Common law judges always had power to change the common law, to create new common law rules, to get rid of old common law rules. And that practice continues. It's subordinate to that of Parliament, and I think we'll find if you look at the details in the case law that judges are acutely aware of this. Even post-Human Rights Act, even after the Human Rights Act, after 1998, judges are aware, and clearly the Human Rights Act doesn't allow judges to strike down acts of Parliament, to declare them void. It gives them enhanced, if you like, interpretive powers to ensure that the common law is developing in such a way that it's consistent and coherent with European human rights law, and this to some extent is a lawmaking power. It comes into tension with Parliament, and the recent news suggests that the present government is themselves acutely concerned that we need to get rid of the Bill of Rights and have then utterly unclear of what this British Bill of Rights would be. All that I think it reflects is a certain disgruntlement with the role that judges have assumed in protecting human rights. I don't want to get too much into that because I think it takes us too far into public law. I want to really keep it under that rubric of the idea that what the judges are doing here are in a subordinate sense making law, and that to some extent brings them into conflict with the executive. Not always, because I think if we read the relevant authorities we can see that the judges are very careful and acutely aware that they've got to be quite precise in the nature of their subordinate lawmaking power. They can't tread on the toes of the executive. It's as if they have an interstitial power to make or change the common law when either Parliament hasn't done so, can't do so, or it's seen to be an appropriate matter for judicial legislation, because not all matters are. We'll come back to these themes. We might talk about them in more detail in the seminar, because I really want to go back to the beginning, this idea of the House of Lords, how it functions, and I suppose a set of considerations that take us to cases like Miliangos, the 1966 practice statement, and the wider tensions that animate this area of precedent. So if we go back to London Tramways back in 1898, which is a long time ago, we find Lord Halsbury arguing the following. And I think this is a really useful starting point. Of course, this is Lord Halsbury speaking, sorry. Of course, I do not deny that cases of individual hardship may arise, and there may be a current of opinion in the professions that such a judgment was erroneous. But what is this occasional interference with what is perhaps abstract justice as compared with the inconvenience of having each question subject to being rear-guarded and the dealings of mankind rendered doubtful by reason of different decisions, so that in truth there is no final court of appeal. My lords, in interest re publicae, the public interest, is that there should be finis litium, an end of litigation, sometime, and that there can be no finis litium if it were possible to suggest in each case that it might be rear-guarded because it is not an ordinary case, whatever that may mean. Now, I think what we've got here is a statement of one version of the doctrine of precedent which stresses rigid authority. And there's clearly an argument, there's a rationale, there's a reason for this, isn't there? And the reason for this is given by Lord Halsbury in that paragraph. There needs to be an end to litigation. If there is a chance that each and every case might be reopened at some later point, there is no finis litium, there is no end to litigation. So the authority of any ruling is, in Lord Halsbury's language, always about to be rear-guarded, reopened. Now, we're all aware of this argument. It's a variation on the floodgates argument, isn't it? It's a variation on the idea that unless we have authoritative rulings, the whole structure of precedent breaks down. Yes, there can only be this need for clear, unambiguous, authoritative rulings by a House of Lords that is never able to depart from its previous decisions. That's the kind of end point that Lord Halsbury's argument makes. And it's not in and of itself a stupid argument, is it? It has certain merits, certain virtues, we could say. It would create statements of great authority. And okay, there's a larger measure of rhetoric here. He says, he refers to this idea of abstract justice. Yes, what justice requires, therefore, is this absolutely clear authoritative statements that can't be reopened. Right? That is presumably not abstract justice, a clear expression of justice requiring a finis litium. And it's fine, but it's clearly an argument open to question, isn't it? Yes, because there are countervailing tensions here. There are other considerations that are equally as compelling. This is really taking us towards the 1966 practice statement. Because what the system is trying to do, what this culture of argument is trying to do, what these rules and principles, if you like, that underlie this culture of argument are trying to do, are trying to balance really two potentially conflicting ideas. The idea that, yes, we need authority. Authoritative legal arguments need authoritative propositions that are not likely to be reopened. Yes, we need to respect the authority of the court, of the House of Lords, the Supreme Court. But what if we could say, well, justice requires something else? Justice requires unusual cases to be dealt with in a different way. Okay, we clearly need authoritative statements, but we need to be responsive. We need to be responsive to different facts, to different problems. We could almost say, switching this argument around, that justice might not be served if all we ever do is privilege previous authoritative decisions. And again, we could really build that argument if we wanted to. The world changes, doesn't it? The world changes. If all we ever do is say, oh, here's the rule and it can't change, but authority is necessary, we create a different injustice. I mean, the Crown and R. Right, here's a clear example of an injustice. At some point in the past, a man couldn't be held guilty of raping his wife. Now, I don't think there's a single person in this room, anywhere possibly, would agree that that is a reasonable principle, an equitable principle, a fair principle, or even a just principle. And the courts are going to look pretty stupid in the eyes of most people, aren't they, if all they ever do is go, oh, this is an authoritative rule and we can't change it. The courts, as we know in R&R, did change that principle to change the law so a man could be found guilty of raping his wife. And I don't think anybody would object to that argument. Okay, it causes a perturbation, perhaps, causes a disturbance in the doctrine of precedent. It goes against possibly what Lord Halsbury is saying. But I think most reasonable people, most sensible people would say, well, there's a justifiable reason for that. It was an old rule. Okay, it might have authority, but there's no point simply stressing authority over all the other possible considerations. So I think this kind of tension then is a real one. Any system's going to have this tension in it. Any system that attempts to preserve both authority and the ability of the courts to move with the times. I know that's a slightly vague expression, but once we look in detail at the cases, later in the lecture and the seminars, I think we'll see that this can be elaborated, this can be given more detail. For our purposes at the moment, in terms of this argument, it takes us directly to the 1966 practice statement. Because my concern with the 1966 practice statement is the way in which it very carefully tries to balance these two, the tension between these two, if you like, principles that we're talking about. The need for authority and the need for flexibility. Because you can't have both, arguably. If something is authoritative, then it's inflexible. One argument. I.e. we can't change it, because to change it is to question its authority. Something is entirely flexible, there's a problem with authority because it's possibly always changing. It's difficult to see why that principle should be authoritative if it's always changing. Yes, subject to complete flux. Those are the two extremes. Nobody's saying that we need a system that is utterly rigid or a system that's utterly flexible. Yes, we're trying to bring together always, the judges are trying to bring together in these key cases, are trying to articulate, find the middle ground, if you like, between these two competing principles. Now, the question is, does the 66 practice statement do that? So let's read it, let's think about it. Here's a quotation from it. Their lordships regard the use of precedent as an indispensable foundation upon which to decide what is the law and its application to individual cases. It provides at least some certainty upon which individuals can rely in the conduct of their affairs, as well as a basis for the development of legal rules. Their lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case, and also unduly restrict the proper development of the law. Now, this next bit's some quotation, some paraphrase, but it builds this argument. I just want to stick with it for a moment. So, in relation to the 66 practice statement, or in the wake of it, their lordships, the House of Lords, resolved to modify the way they approach precedent. So they'll consider that they are normally bound by the previous decisions, but in certain cases they will depart from previous decisions when it is right to do so. Okay, we will depart from our previous cases, our previous decisions of this House, the House of Lords, when it is right to do so. Let's just rewind that argument. Let's make sure we're all understanding where we're going with this. Let's look at the words they actually use. Right? My general point here is it's trying to balance two competing principles, two competing ideas. And I think this is exactly what this paragraph tells us about. Precedent is an indispensable foundation. It provides authority on which to decide what is the law and how to apply it to an individual case. Note this next bit. It provides at least some certainty. Not complete and utter certainty, but as much certainty as we can possibly get. Because it would only provide complete certainty if rules never changed. Yes, that would follow, wouldn't it? If there is always a possibility that rules might change because there's a need for the House of Lords to be flexible, then the best is that we could say is it provides as much certainty as we can possibly get at within the context of the law. It provides at least some certainty on which people can rely, i.e. people are relying on a clear statement of the law, as well as the basis for the development of legal rules. So it obviously not only relates to us, to Joe and Josephine Public, and the way in which we act on our legal duties, our legal obligations, our rights, etc., but it also relates technically to the development of the law, because that's the two sides of precedent. It's clearly providing rules that regulate the social world, but we're also concerned with its internal logic, with the development of legal doctrine. Next sentence, I think, is very important. The lordships nevertheless recognise that too rigid adherence to precedent may lead to injustice in a particular case, and also unduly restrict the proper development of the law. Well, it's going back on what Lord Halsbury's saying, isn't it? It's a critique, it's an argument against Lord Halsbury. Undue reliance on rigidity means that injustice in particular cases might arise. Because if justice requires authority, justice also requires flexibility, a response to the facts of an individual case that may disturb or cause a perturbation within the doctrine of precedent. Justice, and this is perhaps a philosophical point about justice, justice needs to be responsive. Justice needs to respond to the call to be just as much as justice requires authoritative propositions. There's always this tension then. This tension will remain within precedent, it won't be resolved. But I think that's an interesting way to kind of take us through both Lord Denning's campaign in the Court of Appeal and, if you acknowledge a relationship between human rights and justice, something to do with the way in which the impact of Strasbourg jurisprudence is having an effect not just on the development of common law, clearly it is, but also on the doctrine of precedent. This takes us then to, if you like, a technical point. in the wake of the 66 statement, the judges, the lordships, law lords resolved to modify the way they approach precedent. They say we will consider ourselves normally, it's a bit vague because they want to leave themselves room for manoeuvre, we will consider ourselves, this is the judges speaking, normally bound by our previous decisions. But in certain cases, we will depart from them when it is right to do so. Now, what does that mean? When it is right to do so. Have a look at the 66 practice statement. Do you find that there's a little sub-list of situations when it will be right to do so? Are they very precise here? No, they are not, absolutely. They leave themselves a lot of a room for manoeuvre, don't they? To say in this case it is right to do so, in this case it is not right to do so. And the truth is, I mean, if we jump to the chase, if we, read ahead, if you like, if you think about what happens in cases like Miliangos and Shivpuri and Lynch and Howe and all these cases, well, they're very narrowly drawn, aren't they? These instances when the House of Lords will overrule itself, will depart from its previous judgments, they're not doing it every day, because that would take us too far into flexibility, wouldn't it? Yes, we wouldn't know, law wouldn't develop coherently because all the rules would be changing all the time, and citizens wouldn't know how to conduct their affairs because the rules would be changing all the time. So the 66 practice statement, we have to see it working within a context where the times that the House of Lords will depart from its previous rulings are actually few and far between, and they will only depart from their previous rulings on, certainly I would have thought, and I think it would be fair to say, accurate to say, on certain fairly narrowly drawn sets of facts, or when they clearly fall into error, as they do in Shivpuri and Anderson and Ryan in relation to the criminal law. We'll look at that case in a second, but I think it is worth overviewing this idea, i.e. the impact of the 66 practice statement. What it says is quite, okay, slightly vague, but if we interpret that vagueness in the light of those instances where the 66 practice statement has been used, we'll find that it's used quite sparingly. In other words, we preserve the authority of the system by, providing in Lord Halsbury's terms a finis litium, an end point. Yet in those instances where things have gone dreadfully wrong, we hang on to, we open the possibility that the House of Lords can overrule itself. So let's have a little look then in more detail at these instances where this kind of overruling has happened. Miliangos and George Frank. It's funny coming at this case in this way because we need to, to think of it properly, you probably have to look at it in the context of Schorsch-Meyer, and again this would take us back to Lord Denning and what Lord Denning was doing. In Miliangos, the House of Lords overrules itself. In relation, I don't want to get too bogged down in the technical law because we're trying in a sense to think of this in a general way, what it tells us about precedent rather than the material concerns of these cases in which these concerns of precedent are embedded. The case relates, as far as we're concerned, to the sterling principle for the award of damages. And crudely, the historical context here is that given that sterling is no longer the international currency, the courts have to depart from the principle that damages will always be given in sterling because the commercial reality has changed. Okay, so it's sensible, isn't it, to depart from this rule. Even though, if you're Lord Halsbury, you'll say, well, this is not the end of finis litium. We need to hang on to the sterling damages rule. Well, what's going to happen if you hang on to the sterling damages rule? Well, at least at the level of pragmatically, people still simply stop litigating in British courts. Okay, so we've still got sterling damages rule, but nobody's coming to litigate in our courts because they want the damages in dollars or euros or what have you. Yes, so the principle of justice has to open up to other considerations. Whether or not those are entirely pragmatic ones, I'll leave open to question, but that's at least one point we could make in relation to this point. What I want to do, though, is look at Lord Wilberforce's argument in a little more detail because it takes us, I think, to some important concerns about judge-made law. In other words, our fourth pervasive theme. Okay, so this is now Lord Wilberforce talking. The law on this topic is judge-made. So this is from Miliangos and George Frank. It has been built up over the years from case to case. It is entirely within this House's duty in the course of administering justice to give the law a new direction in a particular case where, on principle and in reason, it appears right to do so. It cannot accept the suggestion that because a rule is long established, only legislation can change it. It's an interesting point, isn't it? That may be so when the rule is so deeply entrenched that it is infected interesting metaphor, that it has infected the whole legal system, or the choice of a new rule involves more far-reaching research than the courts can carry out. Indeed, from some research in the matter, I'm led to doubt whether legislative reform, at least prompt and comprehensive reform in this field of foreign currency obligation, is practicable. Questions as to the recovery of debts or of damages depend so much upon the individual mixture of facts and merits as to make them more suitable for progressive solutions in the court. I think that we have an opportunity to reach such a solution here. I would accordingly depart from the Havana Railways case and dismiss this appeal. So what's Lord Wilberforce saying here? Note his first point. The law on this topic is judge-made. Now the suggestion here is if the law on the topic is judge-made, the judges themselves can change it, which is what he goes on to say. It's entirely within this House's duty to give the law a new direction. And you can see no reason why, on principle and reason, there could be an argument made against that. Now, you know, if you're approaching this with this idea that the courts never make law, the judges never make law, it would be hard to make any sense of what Lord Wilberforce is saying, because he's saying the opposite, isn't he? Here's the court making law, it's changing the sterling damages rule. Not only that, he says, look, I'm not going to wait for Parliament to legislate. This falls within the competence of the court. Not all matters fall within the competence of the court, and I don't think it would be right to say either that the judges go, oh, we'll legislate whenever we want, because they don't. They make these careful arguments that Lord Wilberforce is saying here, that given the facts of this case, given the fact that it's largely, not exclusively, judge-made law, that it's entirely suitable for the courts to, well, for the House of Lords to depart from its own previous decision and to change the law, to depart from the sterling damages rule. Questions as to the recovery of debts or of damages depend so much upon the individual mixture of facts and merits as to make them more suitable for progressive solutions by the courts, i.e. not parliamentary legislation. Now, if you read your way into this body of law, we might encounter this in the lectures or in the seminars, we do come across this distinction. I think it's an important one in trying to articulate and demarcate, at least in a general way, when the judges feel that they will legislate or create new law, and when they won't, when they will leave it to Parliament, they will refuse to change the law. And a lot of the time I think it's to do with the judge's own understanding of when it is right and proper to do so. If it raises an issue of policy, let's say, or a broader political principle, or involves the kind of issues, the kind of research that the court can't do, then the judges will say, well, it is correct in this area to leave it to Parliament. However, flip side of that, if they feel that they have the competence to do so, like in Miliangos, they will do just that. They will change the law. Now I want to just jump forward. I mean, it slightly comes out of sequence in terms of my own argument here, but I think there's a nice way in which this point links to an argument Lord Scarman makes in a case McLaughlin and O'Brien. So this is a slight little digression, something slightly outside of this concern, you know, with the structure of the courts, with the hierarchy of the courts. Because remember, our primary point of focus in the argument at the moment is this issue of when the House of Lords can overrule itself. Yes, can depart from its own previous decisions. So far we've thought about Lord Halsbury, we've thought about the 66 practice statement, and we've thought about Miliangos and George Frank. I just want to take a step back from that and take us really to what I advertise as that fourth pervasive concern in our thinking this morning, i.e. judges making law. When will a judge make law? When will a judge not make law? How can we think about the common law in the light of this, of the reality of judicial lawmaking? And that's really why I just want to consider very briefly Lord Scarman's, the general comments that Lord Scarman makes in McLaughlin and O'Brien in 1983. So again, some time ago. And he says this, it's not on the sheet, it's in the book, but I'm just going to read it to you. I think we should just think about it. He's talking about this precise issue that we've been thinking about, the relationship between the courts and Parliament, and when it's right and when it's wrong for the courts, for the judges to make law. He says this, here lies the true rule of the two law-making institutions in our Constitution. He's of course referring to the judges and Parliament, the two, note the expression, law-making institutions, the courts, the judges, Parliament. By concentrating on principle, the judges can keep the common law alive, flexible and consistent, and can keep the legal system clear of policy problems, which neither they nor the forensic process, the process in the courts, which it is their duty to operate, are equipped to resolve. If principle leads to results which are thought to be socially unacceptable, Parliament can legislate to draw a line or map out a new path. Now this is, if anything, and this is the language the book uses, but it's a language that commentators in general, I think, have been developing. Not everybody agrees with it, but I think it's really forcing us to think about a changing relationship in the common law. There's a dialogue, and that is that there's a dialogue between the Supreme Court and House of Lords, possibly the Court of Appeal, and Parliament. Now, I'm not suggesting that they are equal partners in lawmaking, but undoubtedly, I mean, if you look at some of the human rights litigation, cases like A and what have you in the last few years, Pro-Life Alliance case, arguably what we might be finding is a subtle rearrangement of the balance of power in English law, where the courts, in the wake of the Human Rights Act, in the light of the Human Rights Act, now really see themselves as in kind of dialogue with Parliament over these important matters that raise concerns of human rights. Now, I'm not trying to say that's what Lord Scarman's saying. It can't be. This is 1983. So this is not an argument about the Human Rights Act. It's clearly, though, an argument that demarcates the role of the courts and of Parliament. And if we take that back to the language that Lord Wilberforce is using in Millie Angos, we can see that it's moving in a similar direction. What the judges are trying to plot very carefully and incrementally, I beg your pardon, is this the times when it's right for judges to change the law to keep the common law alive and flexible and consistent, and to keep, in Lord Scarman's language, to keep the legal system clear of policy problems which are properly the realm of Parliament, democratically so. Parliament is there to change the law in a general sense. Parliament is a supreme lawmaking power. Now that argument is entirely consistent with the argument that the courts have an interstitial lawmaking power, in this sense that Lord Scarman's talking about here. Or, for example, in relation to what happened in Millie Angos and George Frank. I don't want to blur these things because clearly human rights kind of arguments push that in a slightly different direction. But arguably what they do is they elaborate, they intensify arguments that were being made in 1983 about the relationship between the courts and Parliament. And I think for a sophisticated understanding of what's going on here, which admittedly takes us some way from the textbooks, which tend to have a rather nuts and bolts, this very clunky idea, especially in public law, to some extent, and to some extent in this subject as well. I don't think people are really up to date and really being accurate or serious about the way in which English law, British law, is changing. Perhaps that pace of change has speeded up since 1998. Who knows? I mean, if you're reading the news, I mean, clearly the executive and the courts have come into tension over things like prisoners' rights, which has upset the government because they think the Supreme Court have gone too far, whatever that might mean. We can't, unfortunately, engage with these arguments within this framework here. My point is a general one. Whatever it says in the textbooks, you have to think about quite carefully and say, well, does this match up with the reality as I understand it, as somebody living in 2011, following what's happening in the courts in 2011? Because, as I say, I mean, if we then go back to some of these issues, they're happening some time ago, decades ago. And a lot of people write on this area as if Lord Denning's still alive, as if the greatest thing that happened was Davis and Johnson back in, well, it was an interesting case, it was a very interesting case, but it was 1974. A lot of people think about precedent as if it is still about 1982. Now, in any other field, if your state of your knowledge was that of 30, 40 years ago, it wouldn't be that accurate, would it? If you're a chemist, a physicist, still think it's 90. So I'm just saying, you know, drag yourself kicking and screaming into the reality of modern law. And all these textbooks that go on about things that are happening as if Lord Denning is still there, as if Lord Diplock is still making decisions. I mean, no, I'm not saying this stuff's irrelevant, but I'm saying we need to update it. We need to think about these events from the perspective of now, because otherwise we're simply being inaccurate. We're not accurately describing what the judges are doing. I'm not saying that all the books do that, but the risk is that you are somehow trapped in time, and that these issues, the flexibility of these issues, the way these issues develop over time, can get forgotten, partly because of the nature of the books. The books are not moving fast enough. I mean, the point about the House of Lords overruling itself, to come back to this concern. Now, we know that it's happened in Miliangos, in that area of civil law. We know that in Shivpuri, the House of Lords overruled itself, going back to a decision in Anderson and Ryan, a decision made under the Criminal Attempts Act of 1981. And they did this because they'd got the law completely and utterly wrong. Yes, in the earlier case, they came up with this doctrine of objective innocence, which within the context of the law simply didn't make sense, because the law as it relates to the attempt to commit an offence has to work by reference to the intention of the actor. In other words, if I'm trying to buy drugs, let's say, which was the facts of this case, and I'm sold talcum powder, right, because it looks like cocaine or heroin or what have you, yes, a white powder, in other words, then if we use the doctrine of objective innocence, because it's not drugs, it's talcum powder, I'm somehow innocent. That's nonsense, isn't it? I'm still trying to buy drugs. The fact that the drugs were talcum powder doesn't change my intention, my criminal intention to purchase drugs, does it? A white powder that I believe to be drugs. So the law of criminal attempt, not criminal law generally, has to work from the perspective, if you like, or has to take into account the intention of the actor, the person engaging in potentially criminal activity. And if the House of Lords go the other way and say, oh no, objectively they weren't drugs, therefore this was not a criminal attempt, an attempt to purchase a controlled substance or what have you, then the defendant is innocent. It doesn't work. In other words, that example of the 66 practice statement is an example of the House of Lords falling into error, which we can all fall into error. We hope that the House of Lords don't do it that often, and they don't do it that often. There are a couple of cases where the House of Lords gets the law wrong. But, you know, yes, then this is a correction then, isn't it? So it would be one of those sensible applications of the 66 practice statement that allow the House of Lords to correct itself. And there are other examples, perhaps less dramatic than Shivpuri, Lynch, for instance, which through pressure of time I can't really spend that much time talking about, but it really just illustrates these issues of the instances where in extreme error the House of Lords will depart from its own previous rulings, or in other instances may make different decisions depending on the cast of the law, depending on the doctrine of law that is at stake in that particular instance. I think in some senses then Lynch is less dramatic than Shivpuri, but both these cases take us to these concerns as well in the background, our fourth pervasive concern of judicial legislation. This really then, I think given pressure of time, we have to move on to consider some related issues. First of all, can the Court of Appeal depart from the House of Lords? Now this again was Lord Denning, and it's the easy answer is no, it can't. Lord Denning tried in Schorsch-Meyer, but then in Miliangos his approach was quite firmly rejected. I mean, Lord Denning's argument in Schorsch-Meyer again is, I think, what Lord Denning represents and why he catches the imagination of a lot of people. He's a very creative thinker. And I think his concern in some instances, although in other instances not, but certainly in some instances, is the desire to do justice on the facts of the case. Yes, to introduce flexibility into the law. So if Lord Denning is saying in Schorsch-Meyer, yeah, the Court of Appeal should, in certain circumstances, be able to depart from a previous ruling from of the House of Lords and not be bound by it, because there is a compelling reason to do so. That would introduce a great deal of flexibility into the law, wouldn't it? It would give the Court of Appeal almost equal comity, equal rank with the House of Lords. House of Lords isn't like that. The House of Lords reject what Lord Denning was trying to do in Schorsch-Meyer in Miliangos, asserting the idea of the hierarchy of authority. Yes, because, okay, we're asserting the principle of 66, the principle of the practice statement, which says the first thing we have to consider is authority, i.e. the hierarchy of the courts. We can't have the Court of Appeal suddenly departing from itself, or indeed the House of Lords every other day departing from itself. The times that the House of Lords can depart from its previous rulings are few and far between. Serious error would be one example. We can't have the Court of Appeal suddenly deciding that it is at the same level of the House of Lords and thus able to depart from the rulings of the House of Lords, or not be bound by the rulings of the House of Lords when it considers itself so minded. So Lord Denning's campaign at that level comes to a dead end, unfortunately, for Lord Denning. But I think that, as I say, looking back on these cases, for those people who get, I think, inspired by Lord Denning, it's as if your sensibility or appreciation is that, yes, justice needs to respond. There is a problem with authority. Not that one has to reject it, clearly one can't. The doctrine of precedent works through authority. But it's as if the inspiration is to open up those instances, okay, quite carefully drawn ones, and say in these carefully controlled instances, well, yes, the Court of Appeal should be able to depart from the House of Lords. But as I say, that's a dead end. That's a historical argument. Inspiring, if you are so minded, but not a statement of fact that the Court of Appeal can do that. Clearly, Miliangos, in part, is the authority for why it can't. The other related thing, related in part because it's Lord Denning, and also because I think it takes us to this concern with the flexibility or the need to introduce a greater flexibility in the system precedent, would take us to this remarkable case, Davis and Johnson, which is the issue that's really raised here is, can the Court of Appeal depart from the Court of Appeal? Can the Court of Appeal depart from its own previous rulings if it feels it, or not feel is, if it argues that it is necessary to do so? I haven't got time to talk in massive detail about the facts in this case, but I think it's worth just mentioning the salient issues, because I think it does point up this theme that we are concerning ourselves with. If you remember anything about this case, it concerns a woman who had a violent partner. They had a council flat together. She left the council flat after domestic violence, essentially wanted the right to reoccupy, wanted him out. Now, the cast of the law was such that the Court of Appeal could only do that if it departed from some of its previous decisions. Lord Denning arguing here that the demands of justice are such that it should do this. And in the Court of Appeal, Lord Denning was successful with this argument. However, when it got to the House of Lords, I'm summarising, reaffirmed the idea that the Court of Appeal can't do this. The correct point would be the appeal to the House of Lords. But Davis and Johnson is an inspiring and unusual and inspiring case precisely for this reason, that it shows Lord Denning appreciating that the unusual demands of justice in this case arguably justify departing from the doctrine of precedent, departing from, well, the earlier case, Young Bristol Aeroplane, which lays down the only acceptable framework in which precedent can operate. Lord Denning wants to say, well, the 66 practice statement applies to the Court of Appeal. It's actually of equal rank, equal comity with the House of Lords. It's worth looking in detail at Lord Denning's argument. Sadly, we can't do that within the context of this lecture, but it is worth looking in detail because it takes us through a history of the courts and tries to show that the Court of Appeal is in fact the equal of the House of Lords, and thus should therefore have this, if you like, power to depart from its own previous rulings, partly because of the history of the court, the jurisdiction of the court over it. So it's a compelling argument in some ways, but we know what the downside of that argument is, and ultimately the argument that wins the day in the House of Lords in Davis and Johnson is that this would introduce too great a disturbance into the doctrine of hierarchy. It would give the Court of Appeal too greater power. It would disturb settled authority. People wouldn't know how the law was developing. Now, that, it might be that argument still persuades you. The point is it didn't persuade the House of Lords. So Lord Denning in Davis and Johnson is also ultimately unsuccessful. It strikes me that some of these concerns reappear in the wake of the Human Rights Act. Yes. So, in other words, to what extent, post-1998, with the reception of Strasbourg jurisprudence into domestic common law, to what extent does it reopen this question of the hierarchy of courts? The issue then is not so much the retrospective effect of the Human Rights Act, and there's some dodgy, if you look at the cases Lambert and Cancel, the judges hold that the HRA, the Human Rights Act, shouldn't have retrospective effect, even though the reasoning is somewhat disturbed. It's hard to see precisely why. So I only said that to say I'm not talking about the relationship between Lambert and Council. I'm thinking about another issue, and I'm trying to link this issue to what happened, to that broader argument that comes out of Davis and Johnson, i.e. Lord Denning appreciates the need to do justice, to depart from the judicial hierarchy in order to do justice in Davis and Johnson. To what extent can we find, I'm going to say it no more strongly than this, an echo, if you like, of this concern in the wake of the Human Rights Act, with cases like, it takes us, the question is framed, I suppose, most precisely in a conjoined appeal, two appeals, Leeds City Council and Price and Kay and the London Borough of Lambeth. It concerns, well, let me cut to the chase, this is the key issue that these two cases concern. Whether a court which would ordinarily be bound to follow the decisions of another court higher in the hierarchy should follow that decision if inconsistent with a Strasbourg ruling. In other words, if there is an inconsistent decision from the European Court of Human Rights, should the British court lower down in the hierarchy go with the Strasbourg decision or with the decision of the court higher in the hierarchy, which is nevertheless inconsistent with the decision from Strasbourg? This is the issue in relation to a case that I'm going to call Leeds, because it's got a long title. It's on the sheet. Leeds City Council and Price, conjoined with Kay in the London Borough of Lambeth. Now, I've not got that much time to conclude on this. In fact, what time is this lecture? 34. I've got about, all these clocks are telling different times. According to this clock, we're over. Including to that clock, we've got 3 or 4 more minutes. So I'm going to go with that clock because I think that's the consensus. Okay, so we've got about 3 or 4 more minutes. So I can't go into great detail on this case, but that doesn't bother me too much because I want to really try and point out this broader theme, this bigger theme. The theme, as I've said before I was distracted by time, is an issue that really can only present itself to us in the wake of the Human Rights Act, in the wake of what the Human Rights Act makes possible. And I suppose what's also lying behind my argument here is some way in which I'm linking the idea of justice to human rights. Now, I can't elaborate that in any great detail, but let's just say it's not unarguable that human rights and justice fit together, that human rights is a way of doing justice. Now, if you accept that, then it's as if that concern that Lord Denning had back in Davis and Johnson, back in the 70s, yes, in order to do justice, we have to rework, we have to rethink how the hierarchy of courts work. Okay? Clearly the House of Lords say, no, that's not right, to Lord Denning. Court of Appeal is bound by its own previous decisions. This problem then reoccurs, in my opinion, in a different form, in the form that reflects the fact that it's post-1998, post the Human Rights Act. And really it's a problem that is an elaboration of, or begs the question of the relationship of the hierarchy of courts to Strasbourg. So the question framed in Leeds City Council is, should a court which would ordinarily be bound to follow the decision of another court higher in the hierarchy, in other words domestic court, British court, should that court follow the decision of a Strasbourg decision even if it is inconsistent with the decision of the court higher in the hierarchy? Right? So should the lower court follow, correctly from the viewpoint of the doctrine of precedent, follow the higher court? Or should it follow Strasbourg, a Strasbourg decision which is inconsistent with that of the higher court in the domestic hierarchy? And at least in terms of the case that we're concerned with here, which if you look back, the tension is between two cases, Harrow, London Borough Council, and Kazi, I'm not quite sure how to say the name, K-A-Z-I, and Connor and the UK. It's an argument really about Article 8 and property rights. Okay, so it's a human rights argument. Now in this case the argument is actually rejected. In other words, what is asserted in this case is very similar to what happened in the House of Lords in Davis and Johnson, and that is, the similar point is, assert the value of authority, assert the fact that the British courts must follow the courts that are higher up in the hierarchy. If there's a problem, it's, the proper course of action is either an appeal to the higher court or parliamentary legislation. In other words, even in that respect, even post-Human Rights Act, post-1998, the instances, sorry, let me put that a different way, the courts are affirming the conventional form of the doctrine, in other words, the narrowness of 1966 and the rather limited impact, at least as far as the doctrine, the narrow doctrine of precedent is concerned, of the kind of issues that the Act, the HRA, nevertheless introduces into common law, i.e. the relationship between Strasbourg and the Supreme Court. Not just that, the relationship between Strasbourg, the Supreme Court, and courts lower than the Supreme Court in the hierarchy. There is that case called D, but it's quite anomalous, so I don't think anomalous cases produce good patterns. There is really no pattern. What it seems then at the end of this lecture is that we are, even in the wake of human rights, asserting the need for the hierarchy of the courts, the authoritative nature of the hierarchy of courts. That remains more or less settled. 66 practice statement introduces some instances in which we can introduce flexibility into the system, but those opportunities and the extent of that flexibility is, I think it's fair to say, quite limited. In other words, the culture of argument, the judicial practice of precedent, still is one primarily concerned with preserving the authority of the House of Lords, preserving the authority of the Supreme Court, preserving those values, if you like, of authority rather than flexibility, which is not to say there is no flexibility. It's to say that the dominant principle, the dominant value, if you like, albeit in a qualified sense, remains the idea of hierarchy and remains the idea of authority. I think it would be fair to say then that this culture of argument, this practice of argument, the judicial practice of statutory interpretation, of the doctrine of precedent, takes us to instances where the question has been raised about introducing flexibility in the system, primarily by Lord Denning in the 70s, the 80s, and then later on in a different, arguably related way, by Strasbourg jurisprudence in the wake of the Human Rights Act. These introduce disturbances into the conventional doctrine of precedent. But I think it's probably accurate to say at this point in time, the doctrine remains one that primarily stresses the value of authority, the value of hierarchy. So thank you very much for listening, and I will see you in the seminars. Thank you.